Does the way rape cases are carried out need to be changed following the high-profile case involving the complainant Louise Nicholas, where 3 police officers were acquitted of rape? The Law Commission was asked by the then Labour government to review the law around prior convictions being taken into account. 3 former police officers, I should say. The Commission found wider problems with the trial process and recommended further investigation into whether the adversarial model used in sexual offending trials needed to be modified or replaced altogether. 3 legal academics took up the task and applied for funding from the New Zealand Law Foundation, and we spoke to them at the outset. Now the results of their nearly 2-year project have just been released. Elisabeth McDonald and Yvette Tinsley from Victoria Law School, along with Canterbury University's Jeremy Finn, examined 20 overseas jurisdictions, looking at possible alternatives to the current pre-trial and trial processes used in sexual offending cases here. Their report has been published in book form, called From Real Rape to Real Justice, Prosecuting Rape in New Zealand, and it recommends some significant changes to the current system. To tell us what they found and what they're recommending, I'm joined in the Wellington studio by 2 of the principal researchers, Yvette Tinsley and Elisabeth McDonald. Good morning to both of you.
Good morning. Good morning, Catherine.
Elisabeth, we spoke at the outset of this. Since that time, the former Minister of Justice has certainly spoken quite openly about wanting to make some adjustments to the way these trials are carried out. Where have you got to in your conclusions about the current system and how much it needs to be changed? Do we move right away from the adversarial system here, or do we just make some changes?
Well, I think that what Simon Powell was concerned mainly about was child witnesses. And some, of course, those child witnesses can be complainants in sexual cases, whereas we were looking more specifically at sexual offending across the board in relation to adults and children. We came to the conclusion that rather than moving to a wholesale reinvention at this time, that there were things from particularly the civil law jurisdictions that we might import into New Zealand that might have advantages, particularly from a victim's perspective.
What are the parts of the current system that have really been under scrutiny? What are the problems with the current system?
Well, I think there's a couple of things that we really picked up on. One is that there's really only one way to resolve these issues under the current criminal justice system, which is to go to usually a full defendant hearing, and that has a lot of implications for the experience of complainants. Because when we get to that point, the part of the process that they find most distressing and concerning is having to be a witness in the trial and being cross-examined. So we wanted to sort of pick up on those 2 things, think about other options that might resolve, particularly cases where there's a relationship between the alleged offender and the alleged victim.
This leads us to the title of the book.
That's right. You might want to talk about that.
Why is it called Real Rape, Real Justice?
Throughout the literature and what we found through consultation and certainly in observing the system as it currently operates, the real rape mythology, as it's sometimes called, is that it's a stranger rape, that we have someone who's fighting back, that there may be injuries, that there would be then forensic DNA evidence. And that's the kind of case that fact finders and all of us out in society tend to view as a rape. So, of course, most rapes don't fall into that category. And what we found, and what all the international research before us has found, is that it's those cases that don't fall into the category that are particularly ill-served by the problems of the adversarial system.
Juries are often asked to believe one over t'other. They may be in a relationship, Absolutely. They may be in and out of a relationship, and that gets the straightforward forensic evidence that everyone likes to have is not necessarily going to be there.
Well, if you admit that there's been sexual intercourse, then what does the DNA evidence show? It's showing that there has been some form of intercourse, but if it's around consent, then that becomes a marginal issue.
Can we stop at this point and look at the statistics, because they are extraordinary? What the estimates of how many rapes are even reported, how many get to court, how many successfully prosecuted? What are they?
You looked at the attrition in particular, didn't you, Elisabeth?
There are varying estimates on the reporting rate of sexual offending, but mostly it's seen as very low.
10% is one figure.
Yes, that's right.
I think the recent crime and safety survey thought around 7 or 8 times more sexual violations are occurring than are actually reported.
So if 10% reported, only half of those, I think, typically get into trial?
That's right.
And a third successful prosecutions or guilty prosecutions.
That's right.
So very low rates. So come back to what you were talking about, which is the situation in which most rape cases typically occur. And you can start to see perhaps why those rates are so low, because it is a particularly difficult trial.
That's right. And our rates for interpersonal violence generally, in terms of those conviction rates, are quite low. And what we wanted to focus on, some of our reforms may affect the conviction rate, some of them may affect the reporting rate, but something that is often overlooked is that affects the experience of the process from beginning to end for complainants. So if you're getting in there and you're not hearing reasons about why the defendant was acquitted, then it may feel that you may think that the fact finder just didn't believe you. And of course it may not be that case. It may be that the jury believed that you didn't consent, but they also believe that the defendant had a reasonable belief that you did consent. And a fact finder can believe both of those things, and that's going to end up in an acquittal.
Let's begin right at the beginning. Elisabeth, you were saying at the outset there's only one path currently. Are you suggesting there ought to be more paths?
Yes, well, one of the things that we've been told is that the perceived very high penalties for sexual violation, maximum penalty of 20 years, and that's very, we don't get close to that in very many cases, is part of what might actually put people off complaining, particularly if there's a relationship, it occurs within a family. They don't necessarily want the outcome to be that extreme, but they might want an acknowledgement of the harm. They might want an undertaking that it's not going to continue. But at the moment, there really isn't that option, except in very few cases with some of the good work that Project Restore is doing in Auckland. So we think there is a need for a range of options. They may not all be complainant-driven. Sometimes it will be a question of public safety, so that we have to proceed in those cases to a full defendant hearing in the usual model with some changes. But there have to be other ways to resolve for the complainant those cases where they don't want to proceed with a complaint to the police. So one of them is the potential for more restorative justice options. And the other one that Yvette might talk about is this possibility of a treatment court model.
So where there would be a guilty plea, and it would be an incentive to plead guilty, then we think there should be an option in suitable cases for there to be an assessment of suitability for treatment. And if the defendant is deemed to be suitable for that treatment, then it would be a fairly lengthy programme usually that would be undertaken. That would be pre-sentence but post-plea. So you plead guilty, you go off, you have your treatment, and then when you come back for sentencing, that will affect the eventual sentence that you're given. So that is, again, something that we noticed there was a real lack of treatment programmes, particularly for those who had offended against adults. We think that needs to be utilised much more. We need to be doing more of those programmes for people who offend against adults. And that could be useful in terms of the restorative processes, but also a treatment court model would be an incentive for people to plead guilty in appropriate cases.
From a legal perspective, is there a difficulty in that you have much heavier sanctions than we used to have for rape, much longer sentences? So it is a crime where the Parliament and society has sent a very strong signal with sentencing, and yet you're talking about something that might be significantly different in some cases from the punitive side of things. Is that going to cause a problem for the system?
I think we have to remember that a lot of those cases we're talking about that may be suitable for an alternative justice process like restorative justice, or that might be the treatment model, a lot of those are cases that are not being reported or they're not being prosecuted right now. So it would actually mean that we have a meaningful response to that kind of offending that we're not getting at all now.
And it's not just victims that are saying there should be another way, but also Defence Counsel were telling us there's very little incentive for defendants to plead guilty or acknowledge their behaviour when the risk of lengthy terms of imprisonment is so real. So it's not just for the complainants, but also I think for defendants who may then accept their part in the offending if there were some other options.
The experience of trial for those who proceed to prosecution has already been amended to some degree over the years. The idea that a woman's sexual history ought to be on trial is one of those areas where there's been some amendment, although there's often debate about whether that still happens or not. How else are you recommending the trial process change, and this idea of shifting to more inquisitorial, more judge-led, rather than two lawyers going at it from two extremes? Have you made recommendations along those lines?
We have made some recommendations in terms of the normal defender, the traditional defender trial hearing. We've made some recommendations in terms of the evidential rules to do more. The Evidence Act already, as you said, does a lot, but we have made some further recommendations, and particularly we would like to see a really good model of fast tracking, that it doesn't happen now, even though it should do in some cases, and that would help us to get around some of the problems of delay. And where the fast tracking doesn't happen, then the possibility of pre-trial cross-examination, but only in those suitable cases where there is a real problem with delay. We also think that there should be specialists handling cases, right from the police officers through to the judge, including counsel, that they should all be specially trained. Not that that would be their sole work, but that they would have specialised training. Do you want to leap in with some more?
Well, and the final thing that we've sort of, I suppose, stepped a little bit back from recommending, but certainly recommend that it be looked at seriously, is the possibility of moving to a different decision maker in sexual offending trials.
So no jury trial.
So no jury as we currently know it. The possibility of some lay participation, but we think that there are real advantages to moving away from the jury in these kinds of cases.
What are they? Because straight off the bat, I'd say, if you're talking about, regrettably, a he says, she says, and what was going on possibly in this relationship, and who does one believe and who doesn't one believe, isn't that kind of where the jury's collective wisdom and life experience is supposed to be brought to bear?
Well, I think if we come back to where we started at the beginning and talking about the misconceptions that are out there and the real rape kind of mythology, all of the studies show that, of course, we all are susceptible to that. So from a purely pragmatic viewpoint, it's very difficult, and it's a long-term aim to have much more community education and awareness around those issues. That's something that we do recommend happens, but that is a long-term aim. It's not going to happen in the short to medium term. And if you have most of the jury members who are susceptible to those misconceptions, then the process of collective decision-making is not going to sort that out in the way that it might do if you've just got one or two jurors who have misconceptions about issues. So essentially, if you come back to that idea, then you think, well, what's the pragmatic solution? And the pragmatic solution is to say we can educate a smaller number of people, and you can be educated out of some of those decisions and some of the misconceptions, not all, but some of them. And so we come back to the judge, potentially with some other lay participation, that that's people who we train.
Interesting you say that, because you also said the fact, I don't know whether you meant the prosecutors when you said the fact finders or the jury, who are the ultimate fact finders, will often reach a conclusion but will feel like the test of the law hasn't been met. Your comment earlier. So really, is the flaw necessarily with juries' preconceptions, or is the flaw with the barriers that the law itself sets, the test that the law itself sets?
Well, I think it's important to differentiate between two different goals here. We didn't really come to this project with the idea of wanting to increase conviction rates. We came to it with wanting to give complainants and victims more satisfaction with the process, which may not be anything to do with actual outcome in terms of conviction, for example. So when we talk about moving to a different decision-making model, we're not necessarily aimed at increasing conviction rates. What we're aimed at is an experience of the victim that is more satisfying. So one of the things that could come with a different decision-making model is that reasons are given for the decision, which of course with jury trials that doesn't happen. So you would get that information about, well, we accepted there was no consent, but we didn't find, the belief of the defendant proved beyond reasonable doubt or disproved beyond reasonable doubt, which is not being fed back to victims.
Very interesting point, because the other debate, and where did you get to on this? The other debate that was floated rather controversially was a shifting in the onus of proof from, she or he did not say no, to had you positively established consent. And of course everyone went, my God, this is sexual, our sexual relations don't move along nice signed documents, do they? Where did you get with the idea of shifting that onus?
Sidestepped it really. No. I mean, one of the things we weren't going to do is to look at the substantive law, and that really fits in with that category. We're really talking about process. We did consider it, and we looked at things like, should there be a different kind of offence that is more of a absolute liability offence, where as soon as lack of consent is proved, that's the end of the matter. And there were some people in the sector who were quite excited about that prospect, but we thought eventually that it would be such a shift from how we currently conceive of criminal liability that we don't make any recommendations about that.
And the reality is that at the moment our standard is a negligence standard, which, you know, it's very difficult to get much lower than that unless you go to absolute liability.
Other matters, some of the pre-trial evidence, I think you've touched on that with you've made some recommendations there about things like pre-trial cross-examination. Yeah. What happens now? There was an element of joint project to this, wasn't it? There's a real interest by whom in perhaps translating this into action, and where's that at?
At the time we got the funding for the research, the Law Commission also got a reference from the government. And so we got together and decided that we should work in collaboration. And essentially what's going to happen is we have now produced the findings of our research. The Law Commission will respond to that. And in their public consultation, they will inevitably move forward with some of our recommendations. They may have some of their own, and it may be that they reject some of our recommendations in terms of what goes forward for consultation. But the process now is that they will do some public consultation on some of the aspects of our research, and it's then going through the ordinary Law Commission governmental process from there.
It's an extraordinary comprehensive work, and a lot of work gone into it from all of you. Thanks very much for updating us. I'm sure we'll talk again. Elisabeth McDonald and Yvette Tinsley have edited From Real Rape to Real Justice, Prosecuting Rape in New Zealand. This is a long-running project for them and also for Canterbury University. Jeremy Finn of Canterbury University, into the laws and the processes surrounding the prosecution of rape.